And hello, everybody. Going to give a second to just get things started, and we have to rescue one of our presenters who's in the waiting room. So, one moment, please. There we go. Okay, got her. Let's see if we have Sydney in there. Sydney's in there too. There we go. Should. There we have everybody with us, I think. Hey, Marissa and Sydney. So, welcome. I went through the registration list, and I know that I know a lot of you, or I know your companies, and I thank you for joining us today. We're recording this session, so should you have colleagues that you want to share it with, we will post it on our YouTube channel, and of course, we'll share it with all of our other panelists. So, I'm Karen Giberson. I run the Accessories Council and Accessories Magazine. Our goal is to help our members thrive, and we do that in a lot of different ways. Sometimes they're fun ways, like we have a magazine, or it could be a networking event, and sometimes it's heads up, there's some issues coming up that you need to know about, and this is one of them. And we are so very grateful to have our amazing team of panelists here who can explain it in a much better way than I. So I am going to introduce them. The presentation is provided by the Textile Renewal Alliance, which we have amazing presenters, Sydney Roth and Marissa Adler, joining us. They are two members from a handpicked team of consultants led by Clear Strategy with experience and expertise in extended producer responsibility, which we're going to refer to as EPR, Producer Responsibility Organization, PRO, building information, and textile and apparel circularity issues. Textile Renewal Alliance was founded by the American Apparel and Footwear Association, the National Retail Federation, and the California Retailer Federation. Chelsea Murtha, Senior Director of Sustainability for the AAFA, the American Apparel and Footwear Association, also joined us today for this presentation. I thank you all for coming and sharing your knowledge with our members and friends. I will let you take it from here.
Thank you so much, Karen, for that great introduction. And apologies, everyone, for starting off a few minutes late here. As Karen mentioned, my name is Sydney Roth. I'm one of the consultants supporting the three trade associations in setting up Textile Renewal Alliance. If we could go to the next slide, just to get a few housekeeping items out of the way. Quick legal disclaimer, we will be talking about extended producer responsibility laws in this presentation, but this is all meant to be informational. We're not providing any legal advice or legal recommendations. We're not attorneys nor a law firm, and recommend that you consult your own attorneys and legal counsel for legal advice. And then one more slide. This, as Karen mentioned, the session will be recorded and we will have a Q&A at the end. Feel free to submit questions throughout the presentation as they occur to you. We'll be using the Q&A feature on Zoom, so you should be able to submit questions through that feature at the bottom of your screen. And of course, we will do our best to address all questions that we get during the webinar, but if questions go unaddressed just due to time constraints, or if you have further questions that occur to you after the webinar, please feel free to reach out to us at any time at info@textilerenewal.org. So in today's presentation, we're going to start with an introduction to textile extended producer responsibility, and specifically SB 707, which is California's textile EPR law. We'll also share more information about Textile Renewal Alliance, as well as do a bit of a deeper dive into the obligated producer definitions and responsibilities, as well as some specific considerations for members of the Accessories Council, knowing that you have, unique products that might be have unique considerations and needs compared to other covered products under this program. We'll end with sharing a few next steps and recommendations for how to continue to stay engaged in the implementation of this program. And then, of course, Q&A. Next slide, please. And we can just go straight through. So for those of you who may be unfamiliar, extended producer responsibility, or EPR, is a policy approach that shifts the responsibility for the financial or operational management of a designated end-of-use product to producers instead of where it traditionally tends to lie with municipalities and taxpayers. These EPR programs exist globally for a large variety of different kinds of products, including packaging, mattresses, paint, and there are programs that exist in the US and that exist in California. This usually requires producers to fund the cost of collecting, reusing, and recycling the covered items to ensure that they don't end up in landfill or in the environment. California's textile EPR law focuses specifically on consumer-facing textiles such as apparel, footwear, accessories, home textiles, uniforms, etc. And it prioritizes reuse, repair, and the reuse of responsible end markets. We'll go to the next slide. To dive just a little bit more specifically into 707, it establishes the first textile EPR program in North America, in California. And it requires a few things. It requires producers to join and form what's called a producer responsibility organization, also known as a PRO, and obligates those producers that sell apparel or other covered textile products in or into the state of California to fund the responsible end-of-life management of those products through the PRO. And then the PRO, on behalf of producers, is then responsible for developing and implementing what's called a program plan that meets the requirements set out in the law and in kind of details how those producer funds are being used to meet those requirements. We can go to the next slide. So in the case of SB 707, the covered products list is actually kind of laid out quite specifically in the text of the law. Um, it lays it out a little bit more specifically than you see here on the screen, but we wanted to keep it a bit easier to read. I'll highlight that covered products do include clothing and accessories. That includes costumes, footwear, uniforms, as well as home textiles and home textile accessories like blankets, linens, towels, pillows. If you sell covered products that are covered under a different EPR law in California, those are exempt from this program. We could go to the next slide. So maybe taking just a bit of a step back to focus on the different roles and responsibilities within the textile EPR ecosystem. I've been mentioning producers and the obligated producer parties throughout so far, and we will dive a bit deeper into the specific producer definition for SB 707. But generally, this is usually a brand or maybe a manufacturer who is kind of seen as the owner of that product and puts it into the market. And they're obligated to fund the system and take responsibility for their products after consumer use. Usually they're required to do this through a PRO, which involves reporting on the products that they put into the market that are covered, as well as paying fees. Moving kind of in the direction of the chart, the PRO, or the Producer Responsibility Organization, is generally a nonprofit organization that acts as the operational arm that helps producers comply with the EPR obligations, as well as implements the program through that program plan, according to the requirements of the law. The PRO also, through that program plan, develops the producer fee structure for covered products, will set out reporting requirements, and in the case of 707, will also set performance standards or targets. Staying in the middle and moving up to the state agency, in this case, this is CalRecycle. Um, this body kind of acts as the enforcer or the overseer of the program. This includes developing regulations that further specify the requirements laid out in the statute, as well as ensuring compliance of both the producers and the pro. This includes approving pro program plans and monitoring compliance. And then moving to the last stakeholder here on this chart, service providers. This can also include local governments, are generally those kind of on the ground actors who collect, sort, repair, repurpose, recycle covered products, and then generally they'll report on those activities to the pro under a service agreement or a contract, and help kind of realize the program plan and implement those different waste management activities. I think we'll move to the next slide. And I'll now turn it over to my colleague Marissa Adler, who'll give a little bit more information about Textile Renewal Alliance.
Wonderful. Thank you, Sydney. Karen, thank you so much for giving us this opportunity today. We hope the information is helpful to you all. And as Sydney said, we're here to answer any questions that there may be, and we'll leave plenty of time for question and answer at the end as well. So the Textile Renewal Alliance is a prospective PRO who is applying to Cal Recycle to become the PRO that's selected to oversee SB 707's EPR program in California. There is a requirement in statute that the PRO be a 501c3. So TRA is set up and structured as a 501c3. And it's important to note here that this organization was born out of a collaboration between the American Apparel and Footwear Association, the National Retail Federation, and the California Retailers Association, because collectively their memberships represent many of the producers who are obligated and impacted by this EPR program. And so the role of the Textile Renewal Alliance is to support all producers in meeting their obligations under 707. And we take this responsibility very seriously, and we're dedicated to ensuring that the apparel and textiles that are considered covered products under SB 707 are diverted from landfill and collected, repaired, reused, and recycled after use, so that we can help producers comply with this first in the nation EPR program for textiles. We are very focused on the California ecosystem right now because that is the state, the one and only state in the US that does have EPR for textiles. However, at the same time, Textile Renewal Alliance is structured in a way that it could expand to oversee EPR programs in other states if and when EPR laws are passed in other states. But like I said, right now, our entire focus is primarily on California. And we have developed a team behind the scenes who have experience working in the California recovery ecosystem and through the associations who have a lot of relationships and networks that can help put together a compliant program in California. So the Textile Renewal Alliance's team, as it currently stands, is comprised of representatives from those three trade associations, AIFA, NRF, and CRA, as well as consultants like myself and Sydney and other folks that are part of the Clear Strategies team. And our role really is in getting this organization founded and set up. And so we have a kind of an eclectic array of skill sets that touch on things like PRO formation, EPR compliance, textile recovery, and also relationships with the brands and those who are going to be considered producers under this. So it's important for the PRO to be producer-led primarily, and so that is the direction that and the structure that Textile Renewal Alliance has formed. Because producers in the end are the ones who have to comply with the obligations and who are subject to any kind of enforcement action in the event of any non-compliance. So producers are the ones who have the obligations and carry the risk. And so the concept behind EPR is that the producers also then have the opportunity to drive the bus and figure out, how it works best to develop a program that can comply with the requirements. I'll also note here that we understand that not all of the expertise is currently represented that will be needed, and that expertise is going to shift over time as well as we go through different parts of the program development process and the regulatory development process. And so one of the things that we are highly prioritizing is collaboration with folks across the value chain. Regardless of where you sit, if you have any kind of expertise or stake in the game, we really want to connect with people, make sure they're understanding how this new law will be impacting them, and also understanding what role they can or want to play in the solution development. So stakeholder engagement has been a real focus for us. So like I said, TRA right now has a California-focused leadership. We are built for California and focused on successfully delivering the program for SB 707. I already mentioned that we have a producer-led organization, which includes a board of directors that by statute actually requires a representation from the diversity of covered products in the marketplace. And also incorporates voices from producers that are kind of across the size spectrum. So from very small producers to large producers across lots of different product categories as covered under the law. That's who will be leading this organization from the board perspective. And because the stakeholder engagement part is critical, as we know, for developing a system that will actually function in reality, we formed the California Implementation Working Group, and that is meant to coalesce voices from across the recovery value chain. So collectors, sorters, graders, brokers, thrift, nonprofits, for-profits, repair, anyone who could potentially be part of the be part of the program plan for the service provision. We want to hear from those people from the ground up because there's a voice that they can play and they can bring and lend their expertise and lessons learned across their experience operating their own companies and their own operations, especially in 2026 when we have our needs assessment process. So I'll go through this a little bit quickly here, but basically, we've done a lot of work in the last 6 months or so to prepare for the impending requirements that start hitting across different milestones in the under SB 707. So this year, 2025, we are required to submit an application to Cal Recycle by January 1st. 2026, really the end of this month, we have to submit our application to be considered for the pool of applicants that will be looked at, and then Cal Recycle will select one of those applicants to be the official PRO to run the program in California. Cal Recycle will select an organization, one of those PROs that apply, no later than March 1st, 2026. So we've been doing a lot of work behind the scenes to stand the Textile Renewal Alliance up and to make sure that we have a very fully formed application with a robust stakeholder support group behind us. So part of that includes developing a comprehensive startup plan to guide activities between 2025 and 2030. And we also worked on filing all of our paperwork and getting the 501(c)(3) status officially secured. We worked on developing our mission, our vision, our operating principles. We have a governance structure, again, that balances the requirement for the producer leadership, also with the voices of the stakeholders through the implementation working group. The needs assessment process, which is basically a comprehensive study of the recovery ecosystem in California, which has to be completed within 1 year of PRO selection. And so that's a very short time frame because there's a lot that needs to be studied. So we've started the process of preparing for that needs assessment by doing a request for information to over 275 different stakeholders. It's more of an expression of interest to understand who's out there, who's working in this space, what solutions are already in existence, how do those different stakeholders interact with each other, and what kind of data and information exists and maybe doesn't exist that are gaps that we'll need to go and pursue. Of course, we launched our website, which we'll have a link to in a little bit. We have a newsletter and a LinkedIn channel to keep everyone up to date. I highly encourage everyone to subscribe to the newsletter and follow us on LinkedIn so that you can just kind of be kept up to date as to anything that may be critical for you to know. And we have been holding public workshops and webinars and one-on-one meetings and things like this because the education component of this, especially among the producer community, is going to be a really heavy lift. And so we're trying to make sure that we are making everyone who needs to be aware of this aware of this. So I'm going to go quickly through some producer definitions and obligations because I know that a lot of you are probably wondering if you are a producer. And as is typical with EPR laws, I'm not sure how many of you have experience with any other kinds of EPR laws, but there's a bit of a cascading definition. And the purpose of this cascading definition is so that there's flexibility across the supply chain, so that, different actors across the supply chain can work together to figure out which one is going to take the official responsibility in registering with the PRO and being the one to report. So the first and primary definition of a producer, according to SB 707, is a person who manufactures a covered product or is the licensee of the brand or trademark. If no such person exists under that category number 1 in the state, then the producer is the brand or trademark owner or the exclusive licensee if the owner is not in the state. Then, if no such person exists, it falls to definition number 3, which is the importer of the covered product into the state for sale or distribution. And then finally, if nobody in those first 3 buckets applies, the responsibility falls to the distributor, retailer, or wholesaler who sells into the state. 707 has a pretty strict exclusion requirement, and that's if you're a seller that sells only secondhand products, you're exempted. And then sellers with less than $1 million in annual aggregate global turnover, so $1 million in global sales, basically, only those folks are exempt. And we know that's a pretty low bar. So it does kind of cover most producers of the listed covered products in the ecosystem of obligated producers. Producer obligations. So if you are a producer, you're required to register with the selected PRO by July 1st, 2026. And that's the very first kind of, hard milestone that producers have to comply with. It's written in statute. So it's a legal requirement that if you are a producer, you have to register with the PRO by July 1, 2026. You'll have to collect and report data to the PRO on whatever covered products you sell into the state. And the details around when that reporting happens and the granularity of exactly how to report that data and what data you need to report is to be determined. But it's that data that is in part used to determine what fees you'll need to pay on those covered products into the PRO. So the fees won't take place until about July 2030, but there's a lot of engagement that producers will need to have leading up to that date of starting to collect fees. So producer fees, like I said, are going to be calculated on based on the amount and type of covered products that your organization puts onto the California market. And then it's also going to be based on the cost of the management, the end of life management system that the PRO develops as part of its program plan. And then fee setting will occur after the needs assessment process that I mentioned, because the needs assessment process will identify how much more investment there needs to be in the recovery system in California to meet the minimum requirements of the statute or exceed them. And then that will determine the program plan, and the program plan will, establish what the cost of that whole system is, that total pie that then gets divvied up into fees across different producers. And then there will also be some performance standards or performance targets set by the PRO in the program plan. There may be more clarity coming out in the regulatory development process as to what some of these performance standards might be, but it could apply either to the program itself, like meeting certain collection rate targets, or it could apply to the products themselves. And making this up, one example would be like recycled content requirement. Um, so there's a lot here, and I'll just talk about some before I hand it back over to Sydney. I'll talk about some of the considerations that might be um, that we tried to kind of predict might apply or not apply to members of the Accessories Council here. So under 707, the following accessory items are specifically included. So that includes scarves, bibs, footwear, handbags, backpacks, athletic wear and sports uniforms, school uniforms, other, everyday uniforms for workwear, knitted and woven accessories, like apparel or home textile accessories, jacket, vest, and coats, ski and snow pants. Um, Textile products that are not explicitly listed under the covered product definition are likely excluded. But again, we need to wait for some of the additional clarification that will take place during the rulemaking process. That rulemaking process is one that's led by CalRecycle. It'll start in 2026 through an informal rulemaking process, move into formal rulemaking, and then by mid 2028, no earlier than mid 2028, they will publish final rules and regulations, which will hopefully help clarify any ambiguity in the covered product definitions, and also just specify anything that you might have questions about regarding your own covered products. So examples of items that are not explicitly listed in the statute are things like jewelry and belts, as long as they're not knitted or woven. And we think that eyewear will likely be excluded. But this is also where I have to pull back up that disclaimer that please don't constitute this as legal advice. This is our best interpretation based on our reading of the law. But if you're going to have questions about, I'm sure, some of the products that you sell, and you'll have to consult with your legal attorney, and engage if there are still things that are unclear, engage in the rulemaking process, communicate with CalRecycle about what some of those questions are, and they'll hopefully be able to clarify some of that. Okay, I will hand it back over to Sydney.
Thanks, Marissa. So to maybe put some of all of the obligations that were kind of just shared with you into a timeline context, the implementation timeline for SB 707 kind of runs through about 2031. So as Marissa mentioned earlier, next year in 2026, the Producer Responsibility Organization, or PRO, will be selected by CalRecycle. That will be by March 1st, may come a little earlier. The other, excuse me, important milestone in 2026 especially if you were considered an obligated producer, is the producer registration deadline. So if you are considered an obligated producer under SB 707, you were required to register with the selected pro by July 1st, 2026. Also in 2026, the informal rulemaking process run by ColorCycle will kick off, which will then shift to formal rulemaking in 2027, ultimately ending in about 2028. The earliest date that ColorCycle can adopt the final regulations is July 1st of 2028. Also occurring in that 2027 to 2028 kind of year will be the needs assessment, which is carried out by the pro and is due to CalRecycle by March 1st of 2027. So the pro, as Marissa mentioned earlier, will kick off that needs assessment process upon selection next year, and then conclude with that needs assessment report to CalRecycle, who will then approve, conditionally approve, or reject that needs assessment. Moving on to 2029, within 12 months of the approval of the regulations, the program plan put together by the pro will be due to CalRecycle. And there's a July 1st, 2030 deadline for the final approved plan. Once it's submitted to CalRecycle, they can approve, conditionally approve, or reject the plan. But ultimately, a final approved plan must be in place by July 1st, 2030. Upon that plan's approval is when producer fees will begin. It's likely that producers will have some reporting requirements ahead of that time, as data reporting is a key element of determining producer fees. But fees for this will begin in 2030. And then within 12 months of the plan approval, so in 2031, the program plan must then be fully implemented. And then for performance standards that Marissa mentioned, those are going to kick in by March 1st of 2032. But if there's one key takeaway from this slide, it's that if you are an obligated producer under SB 707, you must register with the selected pro by July 1st of 2026. We'll move to the next slide. And so before we move on to Q&A, I know we're getting a few questions. Please feel free to submit those through the Q&A feature on Zoom. We have a few suggestions and recommendations for how you can start preparing now for the implementation. So if you are a producer or may be considered a producer, it's important to start to understand your obligations under SB 707. This is where consulting your legal counsel to determine where you may fall in that producer definition would be very beneficial. To also start educating internally key staff on the compliance requirements, and then to start to assess your internal data systems to prepare for data reporting, which will be required of producers under this program. And then finally, as I just mentioned, the producer registration deadline, which is producers' kind of first milestone obligation under this law, will be to register with the pro by July 1st of next year. If you're a service provider, it's also a good time to start understanding your opportunities under SB 707 and where your service offerings and infrastructure in California may be beneficial to the implementation of the program. And then prepare to participate in the needs assessment, which Marissa mentioned, but will be kind of a first opportunity for the pro to really do a wide landscape analysis of what's out there and what's working and who's doing that work. For all stakeholders, we recommend signing up for both our newsletter and any future webinars we host to stay informed, as well as CalRecycle's listserv on the Textile EPR program. They'll send out updates as well, specifically about rulemaking. And we really are encouraging all stakeholders to attend the rulemaking sessions and to stay aware of the updates in the rulemaking process, because this is another key area where clarifications on covered products and obligations and program implementation will be made. And we really want to encourage everyone to make sure that their voices are heard. Finally, I'll end absolutely no obligation at all, but if you are would like to support our application to Cal Recycle to be the pro that represents textile and apparel producers, you can scan this QR code to view and sign a letter of support for our application. It's just a pretty simple letter that just signals that your organization is supportive of Textile Renewal Alliance's application to Cal Recycle. And I think that now we are ready to move on to Q&A.
Thank you very much. The only thing I can promise you is that we will also work with the AFA and team and share any updates as they come along. And if it warrants, hopefully ask you to come back and provide any specific updates. So there were a few questions that I thought were good ones. Are anything on umbrellas? Where does that fall into the mix?
That's a great question. It's not well, I have to double check the statute, actually. I don't recall it being explicitly listed. We can check that. But if it's not explicitly listed, then may require clarification if it's a knitted or woven, because maybe it could be considered a knitted or woven accessory, but I don't know. Chelsea, thoughts?
So I would also question for your legal counsel here. Are you currently treating your umbrellas as subject to AB 1817, the PFAS restrictions in California? Because the textile article definition in SB 707 is copied from AB 1817. And so if you currently think that your product is subject to the PFAS restrictions in New York, or in California, it is likely also covered under SB 707. Again, caveat, that's clarify with your legal counsel, but that would be the first question I would kind of ask.
Another question is that some of our categories like jewelry or optical use packaging or cases, or even in the beauty industry, like gift with purchases that wouldn't necessarily classify themselves as a textile provider, but those products are made out of textile. How does that work?
I have a thought
So
here. Oh, go ahead, go ahead, Sydney.
I was just going to say that I don't believe that packaging is in scope of SB 707. I think it's specific to the apparel and textile articles listed in the program. But Marissa, if you have a different interpretation or thought, please share.
I was just going to say a couple of things. One is if your product is covered under another EPR law in California, such as SB 54, which is more packaging, but I don't know exactly the material types they're classifying as packaging under that law, then it wouldn't also be subject to this EPR law because it's already covered by that one. And then the other one is I'll just reiterate what my understanding of the intent of 707 is really these kind of consumer facing textiles and apparel like your clothing and some of those main categories like that. So as you're thinking about that and as you're engaging on any clarifications to the definition of covered products with Cal Recycle or anybody, you can kind of come back to that argument around like, well, what's really the intent of the law versus what are some of the technicalities that, may unintentionally bring in some products that weren't really meant for the main intent.
Great. And we have one great question about the rulemaking sessions. When are they going to happen and how would one be a part of it if they wanted to be?
Yeah, so the specific dates for the rulemaking sessions have not yet been published by Cal Recycle. We'd expect some kind of open workshops in 2026 as part of the informal rulemaking process. And then once that shifts to formal rulemaking in 2027 and 2028, we'd expect to see kind of more formal hearings, public comment periods. So if you'd like to participate in rulemaking, would highly recommend subscribing to Cal Recycle's listserv and of course we will also be monitoring and making sure that everyone subscribed to our newsletter and on our website is aware of these dates once they're published. You can participate through making comments through the workshops. You can also submit written comments once the public comment periods have been opened for drafts of the regulations. But unfortunately, I don't have a more specific answer for you on exactly when in 2026 those first options will be.
So follow along your newsletters and emails for those updates, for sure. You're welcome.
I just would say too, back to the question about kind of packaging or additional items, again, here I would look back at AB 1817 as potentially being instructive. I know, for instance, with smartwatches and PFAS, there was a bunch of discussion about whether or not the smartwatch itself was covered by the textile article ban for PFAS because it had a textile strap, even though the product itself wasn't a textile article. And I think some of that is still kind of being debated a little bit in California, but I do know some of like the major electronic companies have treated it as such that the product needs to be free from textiles. So while I think the intent of the law wasn't necessarily to capture packaging, and that's something that will need to get fleshed out in the rulemaking process, I wouldn't be shocked to see CalRecycle say that actually that packaging is covered, because the fundamental intent of the law is to keep textile waste out of landfills in California. And so, it might be a technicality now, or at least initially, but they could also always expand or redefine the product categories that are covered. But my guess right now is that if you're selling, for instance, like an eyeglasses case separately from a pair of eyeglasses, then that is made of textile. I would expect that to be covered.
Thank you. That's, yeah.
Yeah, I think Chelsea, you raised a good point that made me think too about, battery embedded products and how those might be treated. I don't have an answer for you, but that's another area where it could fall under like a battery stewardship program, or depending on, I don't know, the extent of it. So those are all kind of fringe examples that very well may apply to some of your products.
I would also note too, since this has been an issue for some of the footwear folks, is that while California is calling this a textile EPR program and we are building Textile Renewal Alliance, California defines leather as a textile. And so some of the folks that I have talked to that are in the leather goods space that have assumed that this does not apply to them because they produce leather products, not textile products. I don't believe that understanding is well founded given California law. And that again goes back to AB 1817 and the PFAS textile ban, which specifically notes that leather products are included in that ban.
Yeah, that's a really good, that's an interesting point to call out, because sometimes 707 is sort of material agnostic, because like all bags, all footwear, all apparel is covered regardless of what it's made of. And then on some of those accessory ones, they're like, I don't know if it's knitted or woven. I don't know if you can knit or weave. I don't know. Maybe you can do that with leather. Those are good questions.
Certain categories have to adhere to Prop 65. So I don't know how that works in all this.
So there's not necessarily like a direct connection between Prop 65 and SB 707. In the needs assessment process, there is a particular requirement that the PRO look at PFAS in textiles, but that's mainly with a view towards understanding the kind of scope of the issue of contaminated textiles coming back into a recycling stream and then potentially contaminating future products made with recycled textile. So of course, I mean, always best practice to, minimize chemical usage and to ensure that you do not have chemicals on the Prop 65 list in your product. And that could eventually feed into the eco-modulation process and potential malice fees that come along with that. If you are putting a Prop 65 warning on your product, there's a specific chemical in there that it creates a barrier to future recycling or requires more expensive recycling, for instance. It could be the case that the PRO would assess a malice fee on that product just because it makes it more difficult for the PRO to process when they get it back.
Thank you. That's helpful. And as I understand, there's similar legislation pending in other places.
Yes. So Washington State and New York State both have bills that have been introduced in their legislature. My current understanding is that the Washington State legislature is doing more work on their bill than the New York one is. So I'm not expecting Washington State to pass a full EPR, textile EPR program next year, but they are certainly working on a bill, and we'll be having discussions on a bill come January. And we might end up with like a study or something that comes out of that if they don't move a full EPR program. There's actually two competing bills in New York State on this topic. We haven't gotten the sense that there's a really kind of mature discussion there, in part because I think New York State is really still working through discussions on packaging EPR. And that usually happens before they look at textiles. But I wouldn't be surprised to see other states start to pick this up as well. There are similar textile EPR requirements are going to affect in Europe over the next couple of years. The UK has kind of worked through a quasi-voluntary process right now, and is thinking about a required process. Australia is in a similar spot. So there's a lot of jurisdictions kind of looking at this as a key and interesting policy option going forward. So I would expect more textile EPR requirements to come online in a variety of jurisdictions over the next few years.
Okay, wow, that's a lot. It's good encouragement for everyone to take a good look at their supply chain and their materials, and at least there's a little bit of time to make some very needed modifications. Someone did ask about belts.
Yeah, I think we need probably more clarity. That was our initial kind of an assessment of comparing the list that's very explicit in the statute. But sort of this leather component that Chelsea's bringing up does add another layer of consideration under that. So I think it's TBD.
Yeah, I think just a reminder for folks is the people that are developing these laws are trying to solve a public policy problem, but they're not necessarily people with any sort of deep expertise in the industry. And so definitions are not always clear or particularly instructive. And so that's part of the rulemaking process, that is everybody's opportunity to kind of weigh in and say, like, the way that you have written this, it's unclear to me whether or not I have any obligations. And it's also your opportunity to say, and this is what I would recommend. And so, AFA is certainly going to be involved in that process, and we're happy to stay in touch with Karen about it and make sure you all know kind of when you have opportunities to weigh in there. But these are the kind of things that CalRecycle needs to hear from companies is that they don't know whether or not their products are covered or whether or not they have obligations or if those obligations would make sense, back to that kind of textile packaging question. And so that's why it is really important to be paying attention to this over the next couple of years as the program evolves, because if you lose sight of it, somebody else will answer those questions for you, and without your input. And that could be a pretty significant financial difference and a pretty significant impact on the way you source in your supply chain if you're not aware that that's coming.
Right. Well,
I'll also, oh,
go ahead.
sorry.
Go ahead.
I'll also just add some very practical advice. Chelsea, I've heard you give some really good advice around this. Is some of you may very well have some clear guidance, at least on some of your products that they are covered. And so, Chelsea, can you talk a little bit about the guidance that prep work guidance that you've given around like talking to your supply chain, looking at your data systems, that kind of stuff?
Yeah, I mean, even if you're not 100% sure whether all of your products are covered, the and given, we're telling you that there's a lot that we don't actually know right now, but we know there will be things coming, is that EPR fundamentally is really data intensive. In order to effectively comply or to know whether or not you need to comply, you need to have a lot of data about your products, what they're made out of, where they're made. And this is not just, I'm not just talking about finished assembly, I'm talking about like all of the components as well. And because if you are required to comply, the pro will end up asking you for information about all of those things so it can do an assessment of whether or not you qualify for lower fees or whether or not it's going to have to add a penalty fee, things like that. And what they should do with your product when they get it back into the system. And so the best thing you can do right now is really look at your kind of in-house data infrastructure and figure out, if you needed to pull a lot of detailed information on any given product, would you be able to do it? Would you be able to package it quickly and break it down? Do you have information about any of your products, about their, not just their recycled content, that's a little easier to find out, but their recyclability? Do you know if there's any pathways for that? Do you know if your products have any resale value? Have you talked to any of the resale platforms, that kind of thing? Are you able to get any data? Interestingly, like some of the Goodwills have a kind of treasure trove of data about what your products are worth when they get them back on the secondhand market. They're pretty good at pricing them to move, and so and they have worked with brands and whatnot to provide some of that data to them. And those are all the kind of things that are going to be really helpful for you to know going into this process so that you can advocate for program policies that take into account the way that you make your products, or that don't create penalties that aren't fair for how you're actually doing business. And so those are all things to be thinking about, even if you don't know exactly what the requirements are or exactly how they're going to apply over the next couple of years.
Very helpful. Thank you very much. Okay, I don't see any other questions. So you can, of course, you signed up because you follow the Accessories Council, but if you keep following our newsletter, you can sign up on the website. I will put the recording of this on our YouTube channel. I'll share it with both Marissa, Sydney, and Chelsea so they have the asset. And if you think of any other questions, feel free to reach out. And hopefully the next time I talk to everybody, it will be on a much happier topic. So I wish everyone a happy holiday season, and we're here if you need us.
Thank you so much.
Karen,
We
thank you.
appreciate the opportunity.
For having us.